Mr. Jaffe. All right, this is the, are you here on Van Maren versus Davidson?
Yes, Your Honor.
Or next.
Jasmine Davidson is my client, Your
Or
Honor.
next. What's that? So
Yes,
I see
Your Honor.
Miss Davidson's here. And do I see Edward Van Maren?
Present in the courtroom, Your Honor.
All right, Edward Van Maren is present in the courtroom. So I have a motion for, sir, if you want to come on up, you can have a seat at this table. Oh, actually, you're going to be at that table over there, okay? All right, so I have a motion up for summary disposition. I've reviewed the motion. I reviewed all of the documents that were submitted to the court. And is there anything that I need to be aware of?
Yes, Your Honor.
Your Honor, excuse me.
Wait, one
Excuse
sec. Can I get your appearance, sir? Can you tell me your name?
Edward Van Maren.
Okay, you can have a seat. Mr. Jaffe, give me your name.
Your Honor, good morning. Attorney Brent Jaffe on behalf of Jasmine Davidson. Your Honor, if I could address the court with regards to the motion that I filed, Your Honor.
Okay, so it's his motion for summary disposition. So Mr. Jaffe's gonna go first and then I'm gonna hear your response, okay? All right, go ahead, Mr. Jaffe.
Thank you, Your Honor. The motion was filed, properly served on this individual. Sorry, it was his poor decision to not retain a lawyer because he's not a lawyer and he has no idea what he's doing. That being said, he never filed a response, Your Honor. This is well over a month ago. And not only did he not file a response, Your Honor, but I just want to state for the record, and I have verification, but I don't need to get into it. This might be one of the most disrespectful people I've ever encountered in my entire life.
Before we go any further, let's pause right here because this case is about to go off the rails in a way that only courtroom reality can deliver. What you're about to see is a classic example of how personal resentment, legal misunderstanding, and unresolved relationship trauma collide in front of a judge who has absolutely no patience for nonsense. On one side, we have a pro-SE plaintiff, meaning he chose to represent himself, stepping into Judge Shackelford's courtroom armed with confidence, but dangerously short on legal grounding. On the other side, his ex-girlfriend arrives with actual legal representation, and that difference alone sets the tone for everything that follows. This isn't just about money. This is about bitterness disguised as litigation. Microtransactions, verbal agreements, emotional grievances, and a failed relationship are all about to be thrown into a courtroom that is not designed to untangle personal vendettas. And Judge Shackelford? She's known for cutting straight through the noise. No theatrics, no sympathy for frivolous claims. As this unfolds, watch closely how the judge steers the conversation back to what actually matters under the law, and how quickly emotional arguments fall apart when facts and evidence are required. Trust me, the implosion is coming.
And if I stated to
All right, I don't want any personal attacks. Let's just get to the meat of the case. What is your motion based on? And just get to that. You guys don't have to like each other.
Failure to state a claim, Your Honor. This individual has never presented an iota of evidence to substantiate any claim that he's ever made, but rather this lawsuit was just an attempt for him to defame and harass my client. But again, Your Honor, no response. And respectfully, Your Honor, I would ask that this court hold this person to the same standard that an attorney would be held to. I would ask that my motion be granted accordingly, and this case be dismissed.
Sir, do you have a response?
Yes, Your Honor, I do. First and foremost, I was under the impression that defense never bothered to file an answer to this case to begin with. Moreover, as defense is trying to claim, my attorney was never present during the said case, the previous custody case between defendant and myself. I have been
So let me ask you this. Let me ask some questions. The parties were you married or dating?
dating.
All right, so how long when did you start dating?
We were together 5 years.
When did you start dating?
2018.
When did you split up?
22.
Okay, so you split up in 22. Your allegation is that this
If I may, Your Honor, we started in 17, not 18. Our daughter was born in
Okay.
18.
Okay. So basically the allegation is that a bunch of these miniature charges were made. At the time, were you two lit these charges for like $3, $2, $1? I don't know if these are all like phone games.
That's exactly what it was.
Okay, it looks like phone games to me.
Microtransactions through mobile
So
phone.
these were all charged, at the time the two of you were you living together?
Yes, Your Honor.
All right, so you were living together, you were cohabitating.
Yes, Your
Who
Honor.
was working?
I was.
Okay, and Miss Davidson, did you have an infant at that time?
Yes.
Okay, so there's a minor child. So is it a baby at this time or a young kid? I mean, there's no year on ISC like 1106, 1217, 320. It doesn't tell me the year these charges were made. Like, I can't tell from looking at the documents that were submitted when they were made. It just says year, or it says month and day.
That is fair, Your Honor, and I do have a stack of papers more than an inch thick of 4 years of bank records. I would be more than happy to bring to the
Were you guys living together at that
Yes, Your
time?
Honor.
Okay,
But the record
so,
also showed that she emptied my checking account while I was providing for both her and a minor child. One of those instances occurred while I was at a grocery store with a shopping cart full of stuff, and she still emptied my checking account.
all right, but there's no claim for that in here. I mean, I just see the claim is that I don't mean to call them micro
That's
transactions,
exactly what they are.
but they're like $1.05, $1.05, $4.69, 91 cents, $1.05.
Several hundred in total.
These are, well, what is you made a claim for 6,500.
Yes,
What is-
Your Honor, and if I may also point out that during the custody agreement, when we were ordered by the court week on week off custody on a dozen separate occasions, I made verbal agreement, which I'll quote Pennzoil v. Texaco, and that verbal agreements are enforceable. I made a verbal agreement with defendant to take child on defendant's court-ordered scheduled week so that she could go out with friends in exchange for her to do the same on my week, and I was robbed of that a dozen times on my weeks.
This is where the legal ground starts to crack beneath the plaintiff's feet, whether he realizes it or not. A motion for summary disposition isn't some minor procedural hiccup. It's a serious request asking the court to shut the case down entirely because even if everything the plaintiff claims were true, the law still offers no remedy. And here's the problem. When you represent yourself, you don't get a lower standard. The judge doesn't coach you. The rules don't bend. You're expected to meet the same legal threshold as an attorney who does this for a living. Notice how the attorney keeps bringing the focus back to one key failure. No response, no evidence, no legal theory that actually fits within the court's authority. Courts don't exist to referee breakups or punish people for emotional wounds. They exist to resolve legally actionable disputes. And at this moment, the plaintiff is still arguing feelings while the defense is arguing law. And that imbalance is about to matter a lot.
So for the sake of argument,
This is your guys' kid.
yes.
I'm not a family law court. I mean, none of that is important to me. I have $6,500 of claim damages for a bunch of micro transactions that equal hundreds of dollars. And those transactions all occurred during the course of your cohabitation while you were the primary caregiver.
Yeah, Your Honor,
Wow.
that is correct, Your Honor. That is correct, Your Honor. And again, just to reemphasize that, again, not an iota of information or supporting documents or even be Texaco, whatever the legal scholar is quoting, has ever been presented to me, nor has this person ever contacted me. Again, he was rightfully served, Your Honor.
Well, it doesn't matter. I mean, if they're talking about making agreements outside of their parenting time order and one party's honoring them and the other party isn't, I am a district court judge. I do not do family law. I am not going to overstep my bounds and get involved in that. And certainly, I'm going to tell you my honest thoughts. I did family law for a long time. And if you two can't figure out how to get along on some level, you're going to screw your kid up. I'm just telling you, that's how it is. That's what I see here. And I see it all the time. And it's really disturbing to me because if you two talk poorly about each other, get mad at each other, in front of the child, can't communicate with each other, You are messing a kid up. You are. And I mean, and that's a family law matter. It's not in front of me, but
And Your Honor, I did
I'm
represent.
very
I did
sad to
represent-
see it over and over and over again. Sir, do you have any other documentation that you want me to look at?
Your Honor, if I could actually go back to the motion in which defense made an effort to claim that my counsel never appeared,
Why do I care?
because he's trying to have my case thrown out on multiple grounds.
Here's where the numbers start exposing the flaw in the entire lawsuit. The judge is laser focused on something the plaintiff doesn't seem to grasp. You can't inflate a handful of small, everyday expenses into thousands of dollars just because a relationship ended badly. These so-called microtransactions happen during cohabitation, when both parties were living together, sharing expenses, and raising a child. That context matters enormously under the law. Courts don't retroactively audit relationships. If they did, every breakup in America would turn into a billing dispute. The judge is essentially asking, where's the legal line that was crossed? And so far, there isn't one. No contracts, no fraud timeline, no evidence of unauthorized use. Just resentment repackaged as damages. This is the moment where a personal grievance is officially colliding with legal reality.
He's
Because you
presenting
didn't file
No,
a
he's
response
saying,
to
no.
motion.
Listen, he is trying to get your case thrown out by saying there's no relief and there's no claim, that there's no legal basis for your claim.
So,
That is that you failed to state a claim on which relief can be granted. So I keep asking you, what matters to me is what documentation do you have that she owes you $6,500?
Your Honor, would a couple write a contract for who's going to pick up children from school any given day of the week? No, most couples are not. So in the same sense, if a couple is together and one party owes the other money, are they going to write a contract?
Yeah, the answer is
No,
gonna-
and when one of the so are you charging her for food she ate while she was the primary caregiver for your child and you were at work? Is she have to pay you back for the food she ate?
I'm asking.
I'm asking you a question, and guess what? I got the robe, sir. So I'm asking you a question. Does she owe you money for food, shelter, clothing that you paid for her while she was the primary caregiver for your child?
Your Honor, she does owe me for food, clothing, and shelter. During the 10-month span that I was under false pretenses, we were going to be a family.
Okay, so no. All right, listen. The request for relief in this case was the maximum that was allowed in district court in small claims. It's since been removed, but the amount claimed was $6,500. And the allegations were credit fraud, defrauding by means of solicitation of prostitution, possession of stolen property, promissory fraud, and emotional distress.
The most important moments in the entire hearing, and Judge Shackelford makes it crystal clear. District court is not family court. She is drawing a hard jurisdictional line and refusing to cross it, because judges who respect the system don't overstep their authority, no matter how emotional a case becomes. What's especially striking here is the judge's frustration, not with legal arguments, but with the impact this conflict has on the child involved. She's seen this pattern countless times, parents weaponizing courtrooms instead of resolving co-parenting issues responsibly. And while she's not ruling on custody today, she's issuing something just as powerful, a warning. Courts can't fix broken communication. They can't heal emotional wounds, but they can shut down lawsuits that misuse the legal system as a pressure tactic. And that's exactly where this case is heading.
Okay,
I do have several hundred hours of audio recordings held within my own home, as the Exhibit A submitted by the defense shows that the defendant was made aware that everything in my home was being recorded.
Your Honor, may I address the court briefly, Your Honor?
very brief.
Thank you very much, Your Honor. As a practical matter, I represented my client also in the custody matter for like over the period of like almost a year. And respectfully, Your Honor, I'm not sure why this plaintiff feels he has a platform to do whatever he wants to do, Your Honor. Again, there's no relief has been, nothing's been substantiated, Your Honor. And if he actually took this serious, which I don't think he is, and again, I think it's a pure harassment technique, then he would have hired a lawyer, because that's why people pay a lot of money to go to law school.
All right. I mean, listen, Mr. Jaffe, we don't have to get in the mud though. Like, listen, as far as I'm concerned, I don't see any claim that relief could be granted on. I mean, all of these, when you have two people and look at, I'm going to just use common sense and reason. When you have two people who are cohabitating with a minor child, an infant, or a very young child, what year was the child born in? 2018?
February 2018.
So we're talking about a kid who is not school age,
Correct.
right?
She's 5 now and in kindergarten.
She's 5 now, but all of these purchases, all of these, what I'm calling microtransactions, all occurred while the two of you were in a relationship, while she was the primary caregiver. And there are agreements that are made. I mean, you can look at it with common sense and reason, which is what I'm doing. And we're talking like, look, she likes phone games a little too much. I'll give you that, but you can't come a year and some after the parties split up and claim $6,500 in an action because of transactions that occurred. She clearly had access to money. Did your client go to the grocery store, Mr. Jaffe?
Of course, for the family, of course.
At the time, no, Your Honor, she did not. She did not
Your
have a
Honor,
license.
absolutely. And again, Your Honor,
Yes. I have a court recorder. Do not make her suffer. She cannot type both of you at the same time. Okay, so you're telling me, Mr. Van Maren, that she did not ever have access to any bank account?
She had unlawful access to mine when she saved my credit information in her phone without my permission.
Okay, wait. So the whole time you were together.
My grandfather took me shopping.
So she was never allowed to go to the store or make any purchases?
She went with me.
Explanation right here is devastating, even if the plaintiff doesn't fully realize it yet. Failure to state a claim is legal shorthand for saying, even if everything you say is true, the court still can't help you. That's not an insult. It's a legal conclusion, and it's one of the fastest ways a case dies. The judge is doing what she's supposed to do, stripping away emotion and asking one simple question. What proof exists that legally obligates the defendant to pay $6,500? Not hypotheticals, not verbal expectations, not disappointment. Evidence, documentation, authority. And every time she asks, the answer circles back to feelings instead of facts. Courts don't rule on vibes. They rule on law.
So she had no access to money. It's your statement. This is what you're telling me. She had no access to any money at all while she was staying home with this minor child.
She couldn't be trusted with money, obviously.
Okay. All right. I find that there is absolutely the plaintiff has failed to state a claim on which relief can be granted. We're talking about microtransactions that occurred during the relationship between the parties where they resided together and had a minor child, and Ms. Davidson was the primary caregiver for said minor child.
Your Honor,
Obviously, sir, you have, if you want to file an appeal, sir, you are certainly entitled to that relief. That is my judgment. Mr. Jaffe, your motion's granted.
All right, to the allegation you failed to appear for your appointment with the probation officer scheduled at 8 a.m. on December 18th, how do you plead?
Guilty.
To the allegation you failed to attend individual therapy at the guidance center as scheduled on 12/12, how do you plead?
Guilty.
And then we're doing and to the allegation you failed to attend your individual therapy on 12/13, how do you plead?
Not guilty.
All right. All right, I'm going to accept the 2 guilty pleas as knowing and voluntarily given. All right, so I saw you, Abigail, on the 10th. And on the 10th, I let you turn yourself in for a day next door. I let you turn yourself in because I care more about your job than you do. So then, the day after that, I do this on Tuesday, you miss your guidance, your therapy appointment on Thursday, and then you miss your appointment with Kara yesterday. And it's like I don't know what you were thinking. Abigail, we've had trouble with you since you came in. It's not use violations. Oh, are you shocked by this? Are you surprised? Well, you should not be. You have consistently, if I count your violations, like I know that we're on number 7, but if you look at them, number 7's 3. Number 6 was 1, 2, 3, 4, right? I mean, it's like Kara's bunching them because it makes sense when you have that many violations in a short period of time. But you're consistently, you think this is Abigail's treatment court, and it's not. Yes, you do. It's a 23rd District Court's treatment court program, and you're not special. You're not special in this program.
Line of questioning is surgical, and it exposes the dangerous slope the plaintiff is sliding down. If you start charging an ex for food, shelter, and clothing during a relationship, you're essentially arguing that cohabitation itself was a financial transaction. And once you open that door, it swings both ways. The judge is forcing him to confront an uncomfortable reality. If you want reimbursement for providing support, then you also have to account for the value of childcare, domestic labor, and emotional labor that occurred during that same time. Relationships are not invoices. The law treats shared living arrangements as mutual contributions unless a clear agreement says otherwise. This argument doesn't just weaken his case, it actively undermines it.
Not Abigail. Abigail can cancel her appointments as she sees fit. She can miss things, and it's a consistent pattern. And the response that we always get from you is like, well, I have a job. Well, your recovery is more important than your job. Because if you're sitting in Wayne County Jail, quite frankly, Abigail, on this, it should have been charged as a 3rd, and you should have a felony right now. Because let's talk about your record for a minute. You've had 3 drunk drivings in how long?
Within a couple of years.
Right? When was your first one?
February of 2023.
Okay. When was your second one?
December last year.
Of 23?
Yes.
Okay. Oh my gosh. When was your 3rd?
April.
April of 24. 3 drunk drivings in a year? Less than a year? Am I bad at math?
Just over a year.